From Studio 226 in Orlando, this is Aging Smarter. Aging Smarter is a podcast focusing on making it easier to grow older, to prepare for the future at any age. We aim to educate, entertain, prepare, and amaze you about your life's journey, no matter what you're aging. I'm your host, retired and former circuit judge, Jose Rodriguez. Today, we are joined by two very, very special guests. I had the privilege of working with them when I was on the bench before my retirement. This time I want to introduce to you Lori Loftis and Pamela Martini. Welcome. Lori, tell us a little bit about yourself.
Good morning. I'm happy to be here. I'm Lori Loftis. I work for the Office of Criminal Conflict and Civil Regional Counsel.
My goodness, that sounds so complicated.
I forget it has a fifth district to it also. Long name. I went to undergrad at UNC. I had a very sad day at UCF on Saturday, but very happy for you.
Oh.
And then, and then I went to law school at Wake Forest. And then I have a husband, 2 children, and 2 dogs.
So tell me, what do you do with the very long regional public counsel?
We call it all sorts of things. Sometimes we're the regional counsel office. Sometimes we're just criminal. But one time I went to a seminar and they thanked me and they said, Lori's from the Office of Criminal Conduct. So it gets all sorts of titles.
So what do you do specifically?
So I'm a chief assistant. So I help with the agency's business, but I also supervise the civil side. So guardianship, mental health, all the dependents. So I'm the civil supervisor.
And Martini, you're an attorney here in Orlando, in greater Orlando. And it's greater than others. So tell us a little bit about yourself. Who are you? What do you do on a regular basis?
Yes, good morning. So I'm a private practice attorney here in Orlando. I practice throughout the state in elder law, which encompasses lots of different things, mostly probate, guardianships, and estate planning. And I live in Windermere with my husband. Got 3 kids, graduated from the University of Florida undergrad many, many, many years ago. Went back to law school as an older adult in my 40s, and I went to Barry University Law School here in Orlando, and was very proud to graduate from there. Started my practice.
How long have you been practicing?
When I originally got out of law school, I went to work for the Lake County judicial system as a staff attorney for my first 2 years. That was in 2012.
And you helped draft protocol.
I did. I
approached the court.
I worked with an amazing guardianship judge, Heidi Davis, who was on the guardianship bench at that point, and got to observe a lot of guardianship cases. And, as part of my time there, I developed kind of a manual for parents of special needs kids on guardian advocacy.
Well, it's one of the ones that I use in class.
That's great to know.
It is.
I did take it from a few different sources, so I might have to. Can't say that I came up with it all on my own.
That's all right. Like, yes, an editor is as important as the one who basically writes the document itself.
Exactly.
It's putting it together that, again, benefits the public and benefits anybody who basically is engaged in the practice.
Right. I'm excited it's still out there.
Thank you for doing that.
Yeah, it's very good. Okay.
Lori, when you wind up going to court, from what I remember, these days, remembering is good.
We have a lot of good memories together.
You represented primarily the AIPs, the alleged incapacitated persons. In other words, people that were before the court on petitions for incapacity, on their route to a petition for a guardianship or emergency temporary guardianship, if it was so difficult an issue that, again, emergency temporary guardianship is necessary. But you were appointed by the court, weren't you?
That's correct.
And what did you do? What was your modus operandi, let's say? How did you go about representing the alleged incapacity?
So we are court appointed, so everyone has to be qualified for our services.
And in the Japanese brain, they absolutely poor.
Yes, and a lot of our clients sadly have had very difficult lives, so a lot of them are homeless, have overused substances, misuse substances to cope. They face a lot of trauma, so a lot of our clients are poor, and many without anyone to help them. So we get appointed, and then we go through the process. And a big misunderstanding of our job is we're not best interest lawyers; we're expressive. So we have to represent what our client. So that
It's what they tell you
Mhm.
that you move forward.
And a lot of times that makes families angry, especially in cases where there are mental health issues. And so your client may be saying, they want to go move to California, live on the street, or whatever, and, do your best to navigate through that system. But a lot of families do get angry because they think, how can you be advocating for my child, to do this? I mean, this is more, I guess, in like, a setting where we have a younger adult and with an older adult, which I know we're talking about here today. If there are mental health issues and they don't want any help, then the families get very angry. They're like, how can you advocate for something like that?
What do you look for when you meet your appointment?
So when I go in there, a lot of times, I think with our elderly population, we have clients that either do have dementia, cognitive decline, or we have mental health issues. So I try to, I try to approach carefully, because this is very upsetting that someone wants to do their part. And so try to be as non-threatening and
In other words, want to be their boss.
yeah, exactly.
Awesome.
And take away their rights and their decisions. So I generally try to be very friendly, like, hey, this has been filed. Let's talk about this. And we'll go over everything with them. And with my clients who have dementia type, issues, they don't really understanding and comprehending what I'm
But you're still responsible for
Yes.
advising the AIP about what what is being alleged in the petition for incapacity. How do you do that?
Just talk about it. I'm like, hi, this is, what's being said. What do you think about this? And I go over everything with them. And then we also have a notice of petition. People, I don't know why, attorneys don't. I'm like, I need this notice of petition to read to my client because I'm legally responsible to say, you're hereby notified that these petitions have been filed. Give them the court date, the judge, the time. They have the right to have if they don't want me, they can hire someone else. They have the right to call their own witnesses. So I do have to go through this petition, which is one of the main requirements. But then also, again, like, this is what it means to have your rights removed. And this is what's being said about you. So those type of issues we go.
And if you don't want anyone to come into the courtroom, they have the right of privacy.
Absolutely correct.
Remember that there was a case that we had.
Yes.
That our friend Winter Solomon Cuthbert is also hanging out here. Basically, the folks were just absolutely shocked that there was the right of privacy of your client to not have folks in the courtroom that they did not want.
Yeah,
So
they had the
if-
whole media there, right? Everybody.
And it had to be excused because, again, of the right of privacy. Since we were talking about incapacity. Now, Pam, turning to you, when you have a petition for guardian advocacy, which is different than a petition for incapacity or a petition for guardianship, petition for advocacy, there's certain things that it needs and certain things that it doesn't. Tell me about what you do when you file a petition for guardian advocacy.
So the guardian advocacy statute was really developed for parents of special needs children, adults with intellectual or developmental disabilities.
So it's the difference between disability and incapacity.
Correct.
Disability is not incapacity. The statutes treat them different.
Correct.
Okay?
Because a developmental disability is not something that is going to improve over time, although certainly sometimes an adult with developmental disability through community interaction or social interaction or education can sometimes regain some of the rights that might have been taken away in guardian advocacy. But with a person with dementia, it's a progressive disease. It's going to get worse. It's not going to
You're
get
not
better.
necessarily going to get cured, right?
Correct.
The
Correct.
cure is not in the near future at all.
Right. So an adult with a developmental disability, it's kind of a different standard of proof. We just offer a letter from their physician or maybe some school records that show that they had been diagnosed with a developmental disability. And the rights that are removed are much different. That's a big change, big difference between plenary guardianship and guardian advocacy. So usually a family of an adult with developmental disability When that person turns 18, they get the same rights that every other 18-year-old person gets.
Right.
They can make their own medical decisions. They can make their own financial decisions. They can make their own educational decisions. And if that person needs their parents' assistance continuing on past that 18th birthday, that's where the guardian advocacy statute really helps a parent to have those rights delegated back to them like they had when their child was a minor, so they can get the right to make medical decisions, to participate in educational decisions. Sometimes the school system really cuts parents off when that child turns 18.
As I've heard, also doctors, they
Correct.
refuse to treat. If you've got an 18-year-old that doesn't have the ability to consent, does not have the ability to make medical decisions, parent, the only one
Right.
that's there that's had the child for that long period.
Yeah, that's correct. And it's interesting because I've had families come to me when their child is maybe 16, 17, and they know about this process and they want to get a head start. And I've had other families come to me when their children are now in their 40s or 50s, and maybe they've had no issue the whole time because the family doctor knew them and never questioned, mom or dad making these decisions. And all of a sudden they hit a roadblock.
So what do you do in those cases where you've got somebody that over the 18-year age requirement of the statute?
Well, we have to still provide that medical documentation that it's a developmental disability, meaning they had it before they turned 18.
And that it's significant
And that it's, well,
and likely to
continue, not expected to improve. Will continue indefinitely.
and folks, we're talking about, right, nothing but just out of the statute. These are requirements right out of the statute.
Correct.
It's got to be permanent. It's got to last forever.
Right. Exactly. And that's one of the things that sometimes these parents are very shocked about. Why do I have to go to the court to continue to care for my child? And I have to tell them, the court's going to be in your business for the rest of your child's life. This is not going to end. You're going to have to report. You have duties and responsibilities. And so it's a big thing to take on, a big responsibility.
One of the things that I confronted and one of the things that I remember was that when I first started teaching elder law, one of the local law schools, what wound up happening was that I had a student join the class because he thought, well, first of all, he had a sister who qualified because she had syndrome. The problem was that he felt that his mother, who was the guardian, was not spending money wisely. And he thought that he was going to take the class so that he could go ahead and help his sister. So, it was his parent. He realized that it was a difficult process, that it's not easy to do that. But he told me, well, here in the statute, it says that for guardian advocacy, you don't have to have a lawyer if the court waives a lawyer. And my response was, shoot, it's even you who have had some legal training. You're a third-year law student. Even you, as a third-year law student, didn't really understand what all of this was about. So do you think waiving a lawyer is a smart move? I think he answered, well, with silence, because what we do is not easy. You as the AIP attorney, let me turn back to you. As an AIP lawyer, have a limited purpose. You basically go through the incapacity. What do you do in an incapacity forum? Who do you listen to? Who do you talk to? What reports do you read?
So the court appoints re-examining members. They go out and perform evaluations. They submit each one submits a report with a recommendation. They're recommending a full guardianship, a limited guardianship, or no guardianship. You don't really get a lot of the no guardianships. You're like, wow. And we use those reports, and we try to focus on the least restrictive alternative. So our petitioning attorneys are fabulous to work with, and everyone is just, I think in this area, people are just trying to help have the best outcome for our elderly population. And so if we get reports that have limited, we work together to like what makes sense, what doesn't make sense.
In other words, those rights that get delegated to the guardian, those rights that still remain and are kept.
Yes, we try to have the AIP retain as many rights as possible, and then just try to give the guardian what's needed. And so I can say if it's a case where there's a lot of mental health issues, sometimes we solve it by just giving the guardian the right to make medical decisions, because that's what they're mainly worried about.
In other words, guardian of the person.
Yes, my loved one is Baker acted. I want to be able to step in and help. So we just try to make it. We use those reports to try to make it as limited as possible.
Do you find that the individuals that are appointed to the examining committees, do they all go out at the same time? Is it the AIP?
I'd say that only happens when Winter has to arrange like a interpreter or translator if someone doesn't speak English. They usually all go at the same time, but generally it's all over the place. We have a trend right now. We're having the examining committee members are so, they have too much to do. So they're getting a report in January, then we get one in April, then we get one in June, way outside the timeline. And then we're trying to make sense of like, these are different times and different perspectives. And so we may have more capacity. So,
because capacity is fluid.
Yeah, that was probably way more of an answer than I wanted.
No. That's precisely right. That's excellent.
A lot of considerations.
Right. We human beings are complicated.
Yes.
And there is no real solution that basically takes everyone into consideration.
That's
it's what you do. Now, back to guardian and back to general incapacity petitions. There's a new law that started out that took effect in July of 2024. Basically, what it did is it amended Chapter 709 of the Florida statutes, which is the General Powers of Attorney statute. And what we wound up finding is that supported decision making. One of the things that the rules require that are similar or that were proposed by a grant. There's been a grant of authority by the Florida Supreme Court, is that supported decision making agreements, the court has to be advised that they are in existence. Secondly, the court's going to ask you, is this an alternative, or do we have to still have a guardian advocacy or guardian? So what is your experience? I know it's very, 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 very early, but what is your experience? And if you don't have any experience with supported decision making, what do you make of supported decision making?
So thank you for bringing that up with me this morning, because I actually went and read the statute. I was aware that it was out there. I actually do have one case where a family had a guardian advocacy of person and property here in Florida, but then they've moved to California. And they came back to me and said, California law is so restrictive. Can't we do supported decision making in California? And I said, yes, we can ask our court here to recognize that there is supported decision making in California and try to get this guardianship, discharged and let explore that up there. In my practice, I haven't had anyone refuse supported decision making, but it was very interesting to read the statute. It's just the lowest form of giving someone authority, just really to speak for that person and maybe to get medical information for that person. So similar to a HIPAA release. So I might say, okay, in conjunction with this, or maybe as an alternative, why don't, if this person has capacity to understand a supported decision-making agreement, can they understand signing a HIPAA release? Can they understand signing an actual power of attorney? But what the statute tells us is we have to look at the least restrictive form before we go on to those more restrictive ways of helping a person, either with dementia.
Lori, have you had any experience with supported decision making?
Try to promote it, and I think it would be great after this if we could figure out some kind of training, because with the parents, most of them are pro se. The parents seeking guardian advocate for children are, grown up 18-year-old children are pro se. So I don't think they understand it. We've brought it up a couple times. I think something we have to figure out, and concept of having a team, and I know I've spoken with Victor, we're trying to get this on some of our, it's like formulating a team, because that's part of it that supports the person with a developmental disability, but trying to get people in their busy community to volunteer to be part of this team, I think is a very, but I would love to explore it more because it's not really being utilized.
I have a feeling that basically your pitch is going to be well received because the multidisciplinary has to be able to put together some training along with your expertise. From what I understand, it was Disability Rights Florida was instrumental for a number of years. More specifically, Caitlin Flibbin of Disability Rights, who was the front person moving, maybe taking 2 steps back, 3 steps forward until this law was passed. And I think that they would be a great source to go to for additional training. I know that on your website, if you want to go ahead and check it out, has recommended forms for supported decision-making agreements. So you don't have to go ahead and reinvent the wheel. Disability Rights Florida has done. The way that their website is built for ease of handling, but it can also be difficult for navigation. Maybe that's me not being extremely technologically savvy, but if I can find it, anybody can find it.
It's there.
I was like, yay! There it is.
You don't have to call your kids. For me.
Exactly. There it is. And I think it's a phenomenal service. Now, one of the things that the 393, the Guardian Advocacy Statute, does is it basically avoids the requirement of the court finding incapacity. So an individual saves the finding of incapacity, and you can tell me, is it easier to have someone regain their rights dealing with guardian advocacy situation? I think you may have answered it already, not as directly as I'm posing. Is it easier for someone with a disability to regain the right to do something that's been taken away, or an incapacity?
Well, in my experience, I've done a few different what's called suggestion of capacity. So once a guardianship has been established, it's still the same process, whether it's an incapacitated person who is trying to regain some rights or a person with developmental disability.
3.1 MD.
Correct.
MD.
One new examiner to go back to do a new examination, an up-to-date examination of the person, and come back to the court and say, yeah, there's certain rights that this person is capable of exercising on their own. So I don't know that it's any different, but one other thing I wanted to point out was that in guardian advocacy, there are certain rights that are non-delegable,
Right.
that are not removed. So in that type of guardian advocacy, right to vote is not removed, so that maybe the person can still be capable of voting. The right to get married is not necessarily removed, although I've seen it in a few cases. The right to drive, be employed, to travel, those kind of things that you don't delegate to a guardian, but that are often removed from a person who's totally incapacitated, are not part of the guardian advocacy, which is why it's a less restrictive form of guardianship. But I did have a case where, and sometimes lawyers don't know the difference between guardianship and guardian advocacy, and maybe they do a full guardianship for a person with a developmental disability that maybe is not appropriate. And then the parents realize, oh, now we have to do divorce, and I have to account for all of the money that my child has spent, that he earns at his job, and then he goes and spends at McDonald's. Why do I have to do all this? Because, well, maybe we give those rights back if he's working, if he's earning some money. Maybe it doesn't have to be so restrictive. And so you can go back and tell the court, okay, even though these rights were removed initially, I think that this person is capable of exercising. So,
And hopefully the doctor will agree with it.
and as long as the doctor agrees,
The incredible thing that I have found, and shouldn't be, it's not incredible. It's just the right. When the court takes away right, the court is required to find clear and convincing. But when rights are requested to be returned, who, it's less. It's more likely than not. So preponderance, you give them back. Clear and convincing, you take them away. But
I mean, I actually think it makes sense because taking away a person's civil rights should be the highest person.
absolutely, and the toughest.
And since we want to promote the least restrictive form of guardianship, I think even, the greater weight of the evidence to give it back, you can always take it away again. You don't want to have to keep going back to court. But I think it makes sense.
In your experience, Lori, you find like cases where there's restoration.
I find my highest rate of restoration is probably with a younger person, maybe 10 years old. Just get some treatment and get off the meds and once they're able to stabilize, they're great. Their rights. I think that's probably my highest. Best.
And for exactly that reason, in my practice, I actually will not take cases where it's a mental illness because that's something that on a good day, a person might be fine. And on a bad day when they're not on their medication, they're not fine. And I don't think guardianship is the best way to deal with that. I have one where I kind of got involved after the fact, and it's a clear mental illness, but my client, the guardian, you can't do much with that guardianship. You really can't force people to do things with that piece of paper.
Very, very, very different. You have 47 something, a statute. Off the top of my head, my math does not allow me to recall the statute. But there is a Baker Act statute that basically says that it's 394, right? It's right after 393, which is the right. Thank you, Winter. You're awesome.
We have our in-studio expert.
Yes, we do. Yes, we do. But 394 basically specifically says that mental illness is not to be considered dementia, and it's not to be considered, again, dementia is not a mental illness, and therefore, if you have someone that is ripe for a guardianship, the person does not qualify for a Baker Act treatment because Baker Act is for the purpose of stabilization. It may be somebody who, by the use of psychotropic drugs, can be stabilized until the next episode where they fail to take their medication. But it's a totally different system when you're dealing with somebody who's got mental illness versus somebody who's dementia. It's loss of cognitive.
And one of the interesting things, and I haven't looked at it in a while, so maybe it's changed, but when dealing with my special needs families, I've had people have their developmentally disabled adult child Baker Act severe behavior. My understanding is that the Baker Act specifically says it's not for people with developmental disabilities,
Right.
but sometimes
Exactly.
there's no other option when somebody's putting themselves in a dangerous situation. So I don't think there's a really good avenue for dealing with that.
It looks like that's a statutory gap. Probably needs to be addressed. This supposed some cool to do in a report. We might recommend.
Yeah, because parents of, I mean, I do have a lot of clients with parents with very, with children with autism at the very high end of the spectrum, where they have severe behavioral issues and parent really wants to care for them at home. They're actually putting themselves in danger by doing that. And in a way, putting the adult child in danger as well. But there's just Florida, I hate to say it in public, but it's really the worst state for people with developmental disabilities as far as services. We have an agency that administers these program and these services, but we're one of the lowest in the country. We don't put the funds behind it to support these families and what they need. And so often I do see we're using the Baker Act sometimes when there's absolutely no choice, but there's just really no good options for parents dealing with children that they love and they want to care for, but sometimes they're actually afraid of them and in danger from them. So it's really sensitive.
Well, and before we wrap up, what I'd like to do is I'd like to ask one final question to both of you. What is it that you find specifically about the work that you do that is fulfilling and that inspires grateful? Look.
I think it is. It's just a specific set of problems when you see families that are struggling, and just being able to jump in and come up with a solution and try to work to get the award. And actually, you and I are on a case right now where the board wants something that's going to be a little bit, but that's what the board wants, and we're going to work together to try to make it happen for her. So just getting, the best outcome for the families, helping them fix their problems and be able to function. I guess that's really what seeing happy.
And as lawyers, people come to us when they have a problem.
Yeah.
Right. And the problems that we deal with in our practice are really, day to day helping families manage, these difficult, complicated situations and try and have the best quality of life for the disabled person or the incapacitated person as possible. So I find my area of practice very, very rewarding. My clients give me big hugs when they come out and we have a meeting, or they get appointed to help take care of their children, or when they run into issues during the process of the guardianship, can help them solve. So it's very, very rewarding.
So both of you, I could say, are executive problem solvers.
Oh, fixers.
Definitely. Fixers of the highest order.
We want to thank you here on behalf of all of us who volunteer at work Aging Smarter. This podcast would not be possible without the most impressive Emmy-winning showrunner, Art Miles, to whom we owe everything in terms of what you see and even what you don't see behind the scenes. Thank you, Art. We also want to thank our logo designer, Annie Newburn, and our artificial intelligence maven, Mike Nichols. Finally, I want to thank Jonathan M. of Floyd's Barbershop and on Fairbanks in Winter Park, because this would not be possible without I pointing to my head of gray hair that is properly coiffed today. Thank you, Jonathan M. Appreciate it. And that concludes our podcast, Aging Smarter. Thank you. Please don't forget to thumbs up and to give us recommendations as to what you want to see as far as the programming is concerned. Finally, disclaimer. This podcast is not intended to be legal, provide you with legal advice. It is not intended to create an attorney-client relationship. It is basically for the purpose of opening your eyes, getting you to understand what's happening, so that when you meet your lawyer to ask specific questions about your case, you'll be able and be ready to talk, because you've had a little bit of an education and an understanding of the promises of guardianship and the positives versus the negatives involved with guardianship, guardianship, and so that you can also know what the differences are between them before you get to your lawyer. Because remember, he or she who represents himself is a faithful client. Sorry. And lawyer too, because you can't do both at the same time. So long for now. Till next episode.